Hey, good morning, everybody. This is Lisa Hill, and this is Title Thursday, and I'm here with Shawn.
Good morning.
And today we're going to talk about probate. So I'm actually just going to go ahead and turn it over to you, Shawn. How does probate affect a real estate transaction?
Well, probate actually can have a very profound effect on a real estate transaction because once probate happens, meaning the seller has passed away, one or more of the sellers has passed away, that triggers certain rights and obligations. And when I say trigger certain rights, think about the heirs. So whoever is left behind, that person may not have previously had an interest in the property, but now, because of probate, they may have an actual interest that needs to be taken care of through the closing. So sometimes you might have that long lost cousin or your estranged brother or sister now all of a sudden has an interest in your property, and that has to be dealt with.
So what is probate exactly? I know that it has a lot to do with when people die, but what is probate?
So probate is actually the process of winding up someone's affairs. And so the person who passed, we call them a decedent. That's a legal term. So if you ever hear that or see that in probate documents or in any sort of real estate documents, that's what the word decedent means. And so all of these probate rights and everything that we're talking about today is triggered on death. So that's really the starting point or the ending point, however you want to look at it.
Yeah.
So in a legal sense, a person can die in one of two ways. They can die what we call testate, meaning they had a will.
Okay.
So it's written down somewhere. It may be in a safety deposit box or in a drawer or on a napkin. As long as you follow the requirements of the statutes, then you have a will. The will then be admitted into court through a probate action for the court to determine who gets what and who has to sign what documents. If you die without a will, that is called intestate.
Right.
So just the opposite of testate. And so if you die without a will, your property will pass to your heirs by statute. And so Florida does it kind of weird. So most people think,
of course.
Right? So
what's new?
Yeah. So as far as determining where property will go without a will, the court will first look to see, did the decedent have a surviving spouse? If they did, the inquiry pretty much stops there.
Okay.
If they did not, most people think you look for kids. You don't. In Florida, we go back up the family chain and see, was there any surviving parents?
Oh.
If there are not, then you go down the chain to see, are there any kids?
Okay.
If there are no children, then you go out and look for siblings.
Wow.
So Florida kind of goes down, up, and out. And it's a little weird, but what they're trying to do is find anyone with any relation to the decedent to take the property and try and do what the decedent may have wanted to happen anyways.
Okay.
With the property. Now, in both cases, meaning if you die with a will or without a will, remember back when we talked about homestead, and we said you cannot alienate a surviving spouse.
Right.
So if you and I were married and I had a will and we lived on our property as a homestead and I pass away, I cannot will the property to my brother. Okay. You would retain a life estate, so you can live there for the remainder of your life, and then my brother would get it upon your passing.
Okay.
So in any of those events, you cannot alienate the surviving spouse.
Okay.
And
well, that's good information.
Yes, and so with regard to what a probate is, we have two types of probates. We have a summary administration and a formal administration.
Okay.
And those are determined based on the value of the estate.
Okay.
And so with both of these, we do not count the value of the homestead property. That's part of our homestead protection.
Okay.
So if the estate is worth less than $75,000, we do a summary administration.
Okay.
It's a faster way to do it. If the value is more than $75,000, we do a formal administration. And that can come into play, especially if you as a listing agent are going to be taking a listing that you know is involved in probate. They're going to want to know whether it's a summary or full administration.
Okay.
Because summary can probably likely be finished in about 90 days. Formal can take much longer.
Okay. Yeah. Just the name formal makes
Yeah.
it sound like, sounds.
It's all essentially it's the same process, but the formal administration, there's a lot more notice period to potential creditors, and that's why it takes longer to do that one.
Okay. So let's say that I have a will. Can I avoid probate in a court?
No.
Oh,
Well,
dang.
maybe. Let me qualify my answer. Maybe. So a lot of people think, okay, I have a will and I've left everything, all my real property to whomever in my will. That will still has to be admitted into court through a probate action. And then once that happens, the court will enter a number of orders. So they're going to appoint, most people are familiar with what a personal representative is, or PR. And that person is the individual who can sign documents on behalf of the estate and also sign any real estate documents. They're also going to enter what we call an order determining homestead for the property.
Okay.
And so whenever we are closing a transaction, that's the one thing that we're going to look for is that order, because at that point, the PR typically has the power to then sell the property.
Okay.
So from a title perspective, that's really what we would be looking for.
Okay.
And you asked if with a will, can you avoid probate? So back when we did our joint ownership video, we talked about certain language on the deeds.
Right.
You can use that to avoid probate. So if the deed has Shawn and Lisa, husband and wife, or his spouse or her spouse, joint tenants with right of survivorship, those sorts of language on the deed will avoid probate.
Okay.
Completely. So that's why if title companies or as realtors, if you ask your sellers over and over, how do you want to hold title? That's really when it becomes important, is if should someone pass away, then you can avoid all of this going to court, because probate can be time consuming and fairly costly.
Okay.
It could be several $1,000s to go through a probate.
Okay. Wow. So let's say that I'm taking a listing, what are some of the things that I should look for before I take that listing?
Okay, so in your pre-listing research, you'll probably look at public record and kind of get an idea of what you're walking into.
Right.
So in public record on the property appraiser, if you see the word estate in the owner name, you likely are dealing with a probate situation.
Okay.
So make sure when you are speaking with the person that they are the PR or they are designated as a person that can sign on behalf of the estate.
Okay.
You may also want to ask the status of the probate action.
Okay.
So whether it's summary or formal, just find out where they are in the process. Are they at the very beginning, or are we just waiting on the court to enter the final order? Because you may not want to take the listing if you're at the very beginning.
I was going to say, because if you take the listing and it could take up to 90 days, if we get a contract on that property, like within the first week, that still means that we've got to wait until that probate is done.
Correct.
Okay.
So, you want to be strategic on at what point you put it active or do that.
Right.
And also you may want to ask how many heirs will be involved.
Oh, we've been down that road.
I know we had our Arizona deal.
Yeah.
Last May, we closed a transaction. A woman passed away. Her home was over in the Pine Hills, kind of Ocoee, Claricona area of Orlando. She did not have a will, so it went to probate court, and we got it almost at the very end of the probate. So it actually timing worked out. Guess how many heirs this woman had?
Oh gosh. I'm just gonna say 15.
She had 11.
Oh,
and
I was close.
And typically in that situation, the family would appoint one person, either through power of attorney or just allow them as the PR to sign the closing documents. Well, this family all hated each other. So all 11 heirs showed up to closing. So we had them in 2 separate rooms because we physically could not fit everybody in the room.
Right.
My poor closer, Diane, she was running back and forth with her notary stamp and trying to make sure we got everybody in there. So that was a bit of a circus. So, sometimes if they say we have 11 heirs, you may you may think twice or brace yourself.
Well, I know our deal that we had what, 7?
Yes.
I think we had 7, and it was only 2 that were like, they were like fighting the whole thing, and it was a weird kind of situation anyway. But thank God they were in Arizona, but still, I mean, it was a hassle because they would not allow a power of attorney with just one of the people. So that meant every single document had to be signed individually 7 times by, it was terrible.
It was interesting. And now, something you just said triggered a thought for me. So, and this would be a good trick to have up your sleeve, is in those situations, I know with our 11 heir one, at the very last minute, one sister wanted more money than the others. And I know in your deal,
the same thing.
The 2 in Arizona,
right,
they didn't want to pay for certain expenses. So one thing that I think would be a good idea is, before you take that listing, contact the title company. Part of our closing package is what we call the net proceeds directive. Okay. And that's the document that we have sellers sign. And it tells us as title who to pay, how to pay them, either check or wire, and how much. So it might be good when everyone is agreeing up front, have everyone fill out that form, so that way proceeds are already divvied up. Right. So then you don't get to the table and somebody wants an extra $1,000.
Because I remember our closing actually got delayed a day or 2 because of that.
Yes.
Because the Arizona people were holding out, and they were like, no, we're not paying, which they should have had to pay because it was an expense on the property. But anyway, but we did get it done. But I do remember that we were delayed a couple of days because of that.
Yeah.
So.
And also, just one final thing for all these probate issues and all the documents that will be involved, because probate is very document heavy. As a title company, whenever we have a probate issue, we always send everything into our underwriter for review to make sure we're not missing something. Okay. Because the fear is you miss an heir, right, or someone gets left out, and then 2 years later they pop up and say, well, no, I owned a quarter of that property after death. Mm-hmm. So we always have our underwriter give everything a once over and give us the final okay before we move forward with the closing. Well,
we have something in our family right now that's personally going on. I have a great aunt in Pennsylvania, and she has a pretty large estate, and so she is leaving. She has no children of her own, and so on my mom's side, she's leaving her estate to all of my granddad, all of his children. Okay. Now, what has happened is I have what, two aunts that have passed away. So now one of my aunts, she had 5 kids. So now that attorney in Pennsylvania wants to find out where every single one of these kids are. Yes. Because now they get her part of it. Mm-hmm. So it's kind of like, and this is going on in my family right now. My great aunt hasn't died yet, but I've been helping track everybody down because, and getting addresses and all of that for the attorney, because when she does pass, I think she's like, good Lord, I think she's 96 or something like right now. Wow, she's like, and she's still kicking, but I mean, it could happen any day. And so,
and that can get very complicated. So, and this is getting a little off topic, but I think it's interesting. When someone leaves an estate like that, and let's say you have 3 aunts, each of whom have their kids, but one aunt has passed, but their kids are still alive. There's 2 ways you can divvy up the property. One is called per capita, meaning you take everyone who's left alive, everyone gets equal amounts. Mm-hmm. Or you can do what is called per stirpes. I have no clue what that means.
Sounds like a disease to me.
What's up with these diseases? First it's Bertha, now it's stirpes.
Yeah, that sounds like a disease.
But no, so with per stirpes, what you do is you go one level down from the person who passed away. So in that case, it would be her children. And then you divvy everything up by family line. Okay. So in that case, for your one aunt that's passed, and her 5 kids, they each get 1/5 of her share. They don't get 1/5 of the estate. Whereas per capita, you would take everyone in one pool and divvy it up equally. So it depends on how the will was written, actually.
And I kind of think it's the per herpes thing.
Not herpes. Sturpies.
Sturpies. Oh gosh. Anyway, I think that's the way it is because it's her share that they'll be like, So I think that's the way it goes.
I remember in law school on our trust and estates final exam, we had a situation with this huge family, and this person had passed, and then this kid had this, and it was, one person's getting 1/78 of the estate, and you're trying to figure out and get it all back up to the top.
Right.
So luckily, with real estate sales and title, we don't ever get into that. We let the probate attorney handle that, or the court will determine that. So probate, if you deal with it up front, so on a transaction, if you know these issues are coming, I would get on it immediately, as opposed to sitting back and hoping it all works out.
Yeah.
Because if you do that, it never will.
Yeah. Well, this has been a great topic today, and Shawn Berry's just a wealth of information when it comes to all this stuff, and I really hope that you guys are watching this and you're learning from it, because this is great information. And I just have to say, I'm in a t-shirt today. I typically don't go to work like this. However, our CEO at Aura has asked all the directors to do a yoga class. So I have a webinar meeting at 11, and then I'm doing yoga. So that's why I'm dressed in my really cool, it's my realtor shirt, and it says Orlando is our home. And and that's true. So anyway, just want to let you guys know, I don't typically go to work like this. So you guys have a great Thursday, and next week, I'm sure we'll come up with another great topic.
We'll think of something.
And if you guys have anything that you want us to talk about, just let us know. We'll be happy to get it out there for you and answer any of your questions. So this is Lisa Hill and Shawn Berry. We just want to say you guys have a great Thursday, and we'll see you next week. Talk to you soon.
See you next week.
Bye-bye.